Want to introduce myself, Jay Ruet.
Thank you.
Thank you for having me.
Matt? Okay.
Judiciary. Senate Judiciary is now in session. Senator Reardon's going to lead us in the pledge. Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We're going to start with SB 41 and Senator Birdsall. It's great to see you.
Thank you. It's good to be back, I think.
It is.
So thank you for bringing me in. For the record, my name is Regina Birdsall. I'm the state senator for District 19, which encompasses the towns of Derry, Hampstead, and Windham. And I am the prime sponsor of Senate Bill 41. This was a request by the Department of Safety. As you know, they have had increasing deaths on the highways and increasing problems with speeding. And this bill has been put together to put additional penalties for driving a vehicle in excess of 100 miles an hour. Now, I know in speaking with Department of Safety, we've had issues with people driving 100, 120. They just clocked someone recently at 177. So this is becoming a major problem in New Hampshire. And what it does, I think the Department of Safety has come in and they'll be speaking a little bit more in detail on it. If you're guilty of if you are seen as driving a vehicle at a speed of 100 miles per hour or greater, you will be guilty of a violation and fined not less than $750, plus a penalty assessment for the first offense, $1,000 plus penalty assessment for a subsequent offense, and their license or operating privilege shall be revoked for a period of 90 days. And for a second offense, from 90 days to 1 year for subsequent offense. So that is the concept of the bill. Again, we've had major problems on the highways with deaths, accidents, and this is a way to try and prevent that. And
Thank you very much, Senator. Do we have any questions? Senator Eldershaw?
No, I'm good. Thank
You
you.
good, Senator Abbas? We're all good. Thank you very much for your testimony, Senator.
thank you.
Pete, do we have anyone else on the later sign-up sheet? Thank you. Matt Amatucci. Officer Amatucci, sorry. Good afternoon. How you doing, sir?
Good afternoon. Thank you very much, sir. My name is Captain Matt Amatucci with the New Hampshire State Police. And I'm here in support of this bill. The state police have seen a significant increase in reckless driving, especially those traveling in excess of 100 miles per hour over the past several years. A breakdown that goes back over the last 3 years. In 2022, there were 221 individuals charged with reckless driving. That increased by 39% in 2023 to 308. And then last year, there were 301, which was a 36% increase from 2022. It's a small sample size because we changed systems in 2021. So we only have partial records and data from 2021. The State Police Special Enforcement Unit, which is our aviation unit, has been tracking data longer than that. I have some of that data as well, which has shown a dramatic increase in violators in excess of 100 miles an hour. So back in 2015, there were over 5,000 motor vehicle stops that were conducted. only 23 of them were driving in excess of 100 miles an hour. In 2016, there were 27. 2017, there were 43. 2018, there were 36. 2019, there were 62. And then over the last several years, that has increased 81, 80, 72, 89, 119. So over the last decade, we've seen an increase in speeding operators, specifically those traveling in excess of 100 miles an hour. So to help curb the behavior, increasing the minimum penalties for driving a motor vehicle in excess of 100 miles an hour will act as a deterrent for us.
I have a question for you.
Yes, sir.
Is there a magic, other than, I know it sounds like 100's a great number, it's a nice round number. Any reason it's not at 95 or 105? Why, is there a particular thing at 100?
No, other than it marries up with the current law for reckless operation.
Okay.
So that was carved out a couple of years ago to add that to reckless operation so that it is a major motor vehicle infraction. And we have seen a drastic increase in 90 mile an hour as well. But we would support any deterrent that we can get to help decrease driving behavior and get it back into the more safe, normal range.
Sounds good. Yes, go ahead, Sandra.
Good afternoon. Thank
Good
you,
afternoon.
Mr. Chair, and thank you for taking my question. So increasing the penalties for reckless driving over 100 miles an hour, I'm going to take a leap that the intention is to deter people from driving over 100 miles an hour, and it is not the intention to think there's no thought that this is going to stop people from driving recklessly, but to create a deterrence, correct?
Correct.
Okay.
That's exactly what this will do. It's going to act as a deterrent. It is not going to solve the problem, but it will hopefully help combat the problem that we're seeing.
Small piece of a larger whole. Okay, thank you.
Yes.
Thank you very much.
Go ahead, Sandra.
Thank you for taking my question, and I'm thinking along the same lines. Those of us who sit in hearings and read the law updates in the newspapers annually and things like that are probably not the people who are driving 100 miles an hour. How do you message that out? How is it, one kid gets caught and gets the fine and tells all his friends about it, or is there a plan to make it known?
I'm sure that there would be messaging to help inform the public. 99% of the public are good law-abiding citizens. This is really concentrated on that 1%. And I think the public in general would like to see this. Everybody who drives our roads sees people passing them at very unsafe speeds. There's absolutely no reason to be traveling in excess of 100 miles an hour. Even law enforcement depends on the current conditions. There's a whole list of things that we look at to ensure, is it safe to be traveling, whether it's weather conditions, traffic, road conditions. There's a lot of things, contributing factors that we take into account on top of our training with, audible and visual, warnings to the public when we're traveling at those speeds. These individuals, many of them are passing people on the right, and they're causing fatal car crashes.
One follow-up, Mr. Chairman. One follow-up. Do you have any statistics about whether these are New Hampshire drivers or out-of-state drivers?
I don't have that information.
Thank you.
Go ahead, Sandra.
Thank you, Mr. Chairman, and thank you for taking my question. In your capacity as a trooper or a law enforcement officer, have you ever received any training or been involved in any accident reconstruction?
I have not personally, no, sir.
Thank you. Okay, seeing no further questions, thank you very much for your testimony.
Thank you very much.
Good afternoon. We'll now open the public hearing on Senate Bill 14, and here to introduce it is our great chairman, Senator Gannon.
Thank you, Senator. I'm Senator Bill Gannon. I represent District 23, also known as the wine country of New Hampshire. Let's see, I'm introducing first Bill 14N relative to penalties for certain fentanyl-related offenses. We've brought this bill the last couple of years. It's been 2 or 3 anyways. It's passed in the Senate, has not quite made it over the finish line, so we're going to give it another go this year. In the last few years, I have had people come to me from Seabrook, Kingston. A year ago, it was Fremont, and then Sandown, and they all had the same problem. They happened to be all men, but there were sons. The mothers all came to me. One met me at the dump and said, "Can I talk to you, Senator?" And I said, "Sure." Pulled the tailgate down, and that's where we talked for about an hour. And she said, "My son," it's the same thing as I heard many, many times, my son or daughter, but in this case it was a son, bought fentanyl unknowingly and died from it. And the person who sold them the fentanyl did no jail time. Last year, I believe it was Captain Murphy, who I believe is plainclothes detective from Manchester, who testified that it would be a deterrent to have mandatory minimums, and that he did not believe that without mandatory minimums, he said, you are instilling no fear into the people who sell it. But they want to be home with their families. They do not want to serve time. And if they know that if they sell fentanyl, there will be a definite penalty, it'll stop this, it'll slow anyways, or impair the sales of fentanyl. So we heard his testimony. The way I look at it is sort of like a stool. I want to rehabilitate. I know the other side is going to tell you that rehabilitation is the only way to go, that it's factual, but I have talked to police officer after police officer in the state who tells me a deterrent effect will be having a mandatory minimum penalty. So I want to rehabilitate just like everyone else, but I also want to do 2 things. I want to punish the person who sold and took another human's life. Knowingly selling fentanyl is something that has to be punished in New Hampshire. So there's 3, I look at it as a 3-legged stool. The rehabilitation, you have to be punished. And I look at it as a deterrent effect. You're not going to be selling drugs, which many of the people that these 4 people who were killed, I'm told that they've been right back on the street selling within the same year and getting arrested again. So we want to keep them off the street. We know if they're in jail, thinking about what they've done, it will have a deterrent effect of they won't be there to sell it. So that'll be one definite thing that we know we get. It'll reduce and be a preemptive step. And other than that, I think we've spoke about all these things in the previous years. If you have any questions, I'd be glad to answer them.
Senator Alshaw?
Thank you, Mr. Chair, and thank you, Senator, for taking my question. We share a county attorney's office and
Sure.
a county jail. So my question is, do we have some actual numbers from either our county or one of the other counties showing the anecdotal assertion of the turnaround, that people are going back out and not being held, right? So that's one of
I'm very friendly with
one of the things that you want to overcome with this is a turnstile, right?
I'll work on some numbers from you from
Okay.
Pat Conway. I'm very friendly with her. We talk all the time.
Sure.
I've discussed this with her before, and she also sees it the same way, that it'll have a deterrent effect. I don't have exact numbers for you though, but I will work on that.
May I follow up? Yeah.
Recognized.
Thank you. And the second question is, do we have some information from the county houses of correction or the state prison as to what our capacity would be if we were to take these offenses that exist as they are now? We have statistics on on fentanyl arrests and prosecution. So if you were to translate whatever that number is, and I don't know what that number is, you must have that number. If we were to translate that into incarceration, what does capacity look like at the county level?
Okay.
Yeah.
I'll follow up and get you numbers on those.
Okay, okay,
So that's
thank
fine.
you.
I did have one other thing. Since we've spoken, on SB 14, the police chiefs did have an amendment they wanted me to make, but it was yesterday. I just couldn't get it drafted in time. But I'd just like you to know what it is up front. They wanted an exception. I thought it might help the ACLU too. If an individual cooperates with law enforcement in the furtherance of a criminal investigation which produces an arrest or convictions, then this shall not apply. So they didn't want to lose their confidential informants. That's something that'll get added, and that'll be given to you in the next few days.
Correct.
Thank you, Senator. Senator Gannon, you said, and I don't know if you meant this as part of the bill or not, but you said they knowingly sell fentanyl. And I think lots of deaths occur sometimes when somebody doesn't realize that was fentanyl.
I believe if we look for the exact wording, the word knowingly is in the
So they,
definition. They would have to have some, if they thought they were selling marijuana, I believe, I'll make sure I'll reread it closer. I believe they have to have knowing, capacity, knowledge.
thank you, Senator.
Seeing no further questions, Senator, thank you for your testimony.
Thank you. You can keep going though. You're doing a good job.
Thank you, Mr. Chairman. At this time, the chair recognizes Mayor Jay Ruiz.
Good afternoon, Chairman Gannon, members of the Judiciary Committee. For the record, my name is Jay Rue, and I have the privilege to serve as mayor of the city of Manchester. I'm here today in support of SB 14. As mayor, there's no responsibility that I take more seriously than the safety of the city of Manchester. A big component of which, as you all are well aware, is dealing with the opioid epidemic, and that includes the scourge of fentanyl. The ripple effect fentanyl has had on children, families, and neighborhoods cannot be understated. It has been devastating, and even one life lost is too many. The good news is we are fighting back, and with help from legislative efforts like SB 14, we will make even more gains. In Manchester, we have taken a number of steps to address opioid addiction, including working with our community partners in the state of New Hampshire, and with that, we saw a reduction in opioid overdoses of 24%, and fatality overdoses dropped by 21% in 2024 over 2023. These are incredibly encouraging results. We rewrote our opioid strategic prevention plan as well, and we have great relationships with our Doorways program. Thank you to the state of New Hampshire for setting that up as well. And additionally, in December of 2024, we recorded the lowest one-month suspected opioid overdose response total in nearly 5 years in the city of Manchester. So we are making progress, but that's exactly why we cannot let up in our efforts, and here's why. A couple of statistics. Of the 4,500 arrests conducted by the Manchester Police Department in 2024, 889 of them were drug-related. That's nearly 20%. Nearly half of those drug-related arrests were for fentanyl or heroin. The number of cases with fentanyl greater than 5 grams was 103. 26 of those were greater than 28 grams. In total, the city of Manchester seized more than 7,300 grams of fentanyl and heroin in 2024. And that's where SB 14 comes in. By establishing a mandatory minimum sentence of 3 years and 6 months for those convicted of possessing 5 grams or more of fentanyl, and sentences of 7 years in prison for those convicted of possessing 28 grams, we have even more ammunition to combat the scourge on our streets that has ruined too many lives and stolen too many futures. SB 14 sends a strong message that New Hampshire is serious about deadly drugs like fentanyl. And if you are found in possession of this killer drug, you will face significant jail time. Unfortunately, I cannot stay to testify for SB 15, but if I may, I would like to just speak briefly in support of that. Okay. As a person in long-term recovery, there is nothing more tragic than when a person succumbs to addiction. Those who sell them drugs should unequivocally face a stiff punishment for their actions that directly lead to a death. To close, prior to becoming mayor, I worked on addiction issues at a national nonprofit that helped people with addiction-related matters and their families as well. Those are people who had sought rehabilitation, sought treatment, those who have been impacted by addiction and had lost loved ones. I do not believe in criminalizing addiction, but I do not believe that that is what these pieces of legislation do. When a person is peddling this poison, they must be prosecuted and taken off of our streets where they are hurting our quality of life and those with a substance use disorder. So I would thank you for your time and your efforts on this critical issue. And please know that the City of Manchester stands ready to answer any questions that you may have and be supportive of your efforts here today.
Seeing no questions? Thank you.
If I may, respond to a couple of the questions before, just because I had a couple of those statistics. So for Hillsborough County, obviously adjacent to you all in Rockingham, the jail, the last time I had asked our superintendent, we were roughly a half to a third full. So there is locations where these individuals could be placed so that the overcrowding, to me, at least in Hillsborough County, I can't speak to Rockingham or Merrimack, but in Hillsborough County, capacity would not be an issue. And I would just add one piece. Deterrent, I think, is certainly an important piece of this. There are also those people that just need to be punished and taken off of our streets. And I think that this would do this. Bail reform, we can get into it at a later time, but I worry about that cycle where an individual is arrested, either serves no jail time or very limited jail time, and then is back on the streets of Manchester to continue to commit these crimes. So thank you again. I appreciate the opportunity to be up here with you, and I appreciate the invitation.
Thank you for your testimony.
Is it on now? Okay, I'm sorry. My name is Melissa Davis. I'm currently the director of the Criminal Practice Clinic at UNH Law. I'm also an associate professor at UNH Law. Prior to joining UNH Law in 2020, I was a public defender with the New Hampshire Public Defender Program for 15 years. I've been a criminal defense attorney in this state for 20 years. I started practicing prior to what we consider the opiate epidemic and have engaged in the practice of law and the representation of people charged with these crimes over the last 20 years. I would like to say I'm opposed to this bill. I'm not here on behalf of UNH. I am here on behalf of the New Hampshire Association of Criminal Defense Lawyers. I do want to speak to just some of the statistics that were mentioned just earlier as far as the purpose of this. I did look to see what the overdose numbers are currently, and you may know them, but in 2022, the number of people who died by overdose in New Hampshire, 427. In 2024, just 2 years later, that number is 199. It's gone from 427 to 199. Now, there are cases pending with the medical examiner's office, but even if every single one of those turns out to be an overdose, it only raises it to 245. That's 427 to 245. That's without mandatory minimums. That means what we're doing is working, and what we're doing is harm reduction, treatment, and prevention. Those things are working, and I see them working in our communities, and I see them working in our courts. Lowering demand through treatment addresses supply. Second thing is, I work with hundreds of clients, people who are sick with substance use disorders, and mandatory minimums are not a deterrent. It is not a consideration that someone takes into account when they are suffering from this disease, when they are feeling the effects of withdrawal, and when they are trying to feel better by taking this drug. Yes, there are alternatives, and yes, treatment is complicated, but the deterrent effect of a mandatory minimum is not something that's playing into people's minds in these situations. What I will say is that these are sick people who are in need of help, and the amounts here, 5 grams, is personal use. It may seem like that's a dealing amount, but there are people who are using 5 grams. I have clients who are using up to 10 grams a day. That's serious and significant, something that should be addressed. But these are personal use numbers that are going to result in mandatory minimum sentences for people who are in our communities who are sick. And mandatory minimum sentencing is contrary contrary to the science of addiction. I understand this as possibly amended by the police, that you believe this may encourage cooperation. I can tell you cooperation is occurring already, and the incentives to do so do not require mandatory minimums. The maximum penalty on this is either 30 years or life in prison. Those are significant sentences that can, encourage cooperation. What also encourages cooperation? A number of other levers throughout the criminal legal system that can be used in these matters. Additionally, it's complicating. I don't want to get in the weeds because yes, I'm a litigator in this matter, but putting police in charge of who gets to cooperate and when, and the effects and the benefits of this, I think is a system that's ripe for bias. It includes when it's at the police level, when it's at the prosecution level. This should be handled by our judges who are very well experienced and capable of sentencing in these matters with high amounts, with people who are found of high amounts. As far as the costs, there were some questions about the county costs. This is not a county cost. These are New Hampshire State Prison numbers. The mandatory minimum is sentences at the New Hampshire State Prison of 3.5 years. The numbers that I could find that I think are most reliable, and those are from 2021, indicate that per individual for a 3.5-year sentence, it's going to cost $190,000 and $190,351 per individual for each of these mandatory minimums. I believe the cost has risen recently. If I'm reading New Hampshire DOC numbers at $176 a day, it goes to almost $250,000 per individual who is sentenced under this law. There's a lot of individuals who are engaging in what is essentially the result of a substance misuse disorder. The federal numbers are much higher. For feds, the guidelines are 40 grams in this place, and I believe it is 5 years. 400 grams is 10 years. Those are substantial numbers, and the federal system is addressing it, and the federal system is experienced at engaging in cooperation and sort of investigations targeted at those dealing high numbers. This doesn't take into account the cost of litigation in these matters. When you put mandatory minimums on the table, people don't plea. They go to trial. And the costs on county attorney's offices, public defender programs, and others in this area, because there is less room for negotiation, are significant in this way. Finally, I will say there are a couple of parts of the bill that don't actually, I think, comport with the law. If someone is deemed incompetent, they cannot proceed to trial, they cannot be convicted. And so the section under there is not consistent. The law in New Hampshire is if you are charged as an accomplice, you are charged as the principal in every single crime in this state. And I think there would be some significant consequences under that subsection. I think, again, by sort of forcing people to, if the intent of this law is to encourage people to engage in cooperation or plea deal or plea bargains as a result of trying to negotiate away from the mandatory minimums, again, we are infringing on individuals' constitutional rights, their ability to challenge the protection of those rights under the 4th and 5th Amendment. And finally, what I'll say is that there are programs that are working in our courts right now because this is a matter of use, that this is a matter of people who are high risk, high need oftentimes. They're directly addressed by our county's drug courts. Every county in the state has a drug court. Those drug courts, through scientific research, have determined that the people who are best targeted by these drug courts and result in the best numbers for recidivation with this community are those high risk, high need. Mandatory minimums would take those people out of drug courts in this situation. What we're doing is working, in my opinion, based on the numbers that I've seen before, and the costs are extremely high in addition to the individual impact. I'm not here to speak as someone who is individually affected, but I work with these people all the time, and I hope that you will listen to those that are. Thank you.
I have a question for you.
Yes.
I think others do too. You were sort of implying like that 5 grams is not a lot of fentanyl. How big a dose? I have a pharmacist who may or may not show up here today. But he was under the impression, it's one of the senators, that 5 grams is a lot, that a very small amount, much like a 10th or 100th of this could kill someone. So when you're saying that 5 grams isn't a lot, I'm surprised to hear that.
And that's correct. And it's due to the nature of the fentanyl use. I mean, the more you use, the more that you sort of need in this situation. I mean, I think initial users, 5 grams is a lot. However, I definitely have, people who are in heavy use that are using 5 grams. I've seen all the way up to 12. I think, 10 is extremely high, but it is not, I don't think, uncommon. I think if you were to ask law enforcement if 5 grams is personal use, they'd have to agree that it can be.
Follow up. So if like 5 grams, so it could be a lot. If this was distributed to my children at a party and got into marijuana or something, it could be enough to clean the room and kill them all. So it could be a lot of, you're talking about a heavy user that it might not, or I'm more thinking that this could fall into the hands of anybody.
Correct. And I mean, I guess this is sort of intended at who, if someone is possessing 5 grams in this situation, my concern is that, this could be individuals who are engaging in personal use.
Thank you. Senator Abbas?
Thank you, Mr. Chairman, and thank you for taking my question. I'm gonna So am I understanding you correctly that there are people that are consuming 5 grams of fentanyl in a day and not overdosing?
Am I good now? Sorry. So I'm not experienced in this, but I will tell you that, my understanding is that over a period of day, yes.
Thank you.
Thank you for your testimony. Ian Wargo, Director of Recovery. Mr. Wargo, that's the name.
You did, perfect, thank you.
Okay.
Whoop.
Yeah.
Good afternoon, Chairman, and good afternoon, members of the committee. As said, my name is Dan Wargo. I'm the Director of TLC Recovery Programs. We have recovery centers in both Claremont and Lebanon. Prior to this, I'm also a licensed drug and alcohol counselor and have been for the last 7 years. In my previous role, I was a counselor for the Department of Corrections in Sullivan County. They have a 3-month in-house treatment program within the jail that I oversaw, and I counseled people through the process. In another chapter of my life, I'm also a person with a history of drug and alcohol abuse. And as a result of that abuse, I found myself in institutions, jails, and homelessness. I'm sharing that all with you because I feel that I have some pretty good personal and professional experience when it comes to substance use treatment, and incarceration. I'm coming here today to extend my deep concerns for these bills. While working in corrections myself, I have seen the benefits of people getting criminal charges for their offenses that are drug related. What I'm opposed to is when punitive approaches prioritize treatment. We have to remember here, it's really crucial to remember that we're dealing here with an illness. An illness, as it was mentioned here, that a lot of people who might have possession of 5 grams or more are not distributing, they are just users. That treating that illness with crime and punishment ultimately is ineffective. Much better approaches, as I'm sure you've already are aware of and been told are along the lines of treatment, prevention, and recovery. I was actually at a team meeting this morning with my recovery team, all of which are people in recovery themselves or in sustained recovery, and work diligently to help other people who are struggling with the same issues. And I was telling them that I was coming here, and I was kind of sharing the bill with them a little bit. And I asked them, I'm like, how many of you, knowing that nobody on my team has ever been a dealer, how many of you have been in possession of 5 grams of fentanyl? And every single person raised their hand. And then I asked them, well, where would you be if this happened to you? And the general response that I got was, I don't know where I'd be, but it probably wouldn't be here. And these are people that are having a huge positive impact on addressing this issue, on helping people who are struggling to get to the other side. People using their own personal experience and recovery to help other people be successful. People who wouldn't have any opportunity to do this if mandatory sentencing was in place, such as this. I also feel that there might be just a little bit of things to mention as far as my understanding about, the drug world, in the sense of the drug world is a business world, and you have essentially drug lords, and everybody who's in the drug world essentially is replaceable, especially the people who are distributing it in small amounts. There's been so much research and study that has already shown that minimum sentencing, at the degree that this is ineffective and doesn't work nearly as much as prioritizing treatment over it. I feel like that there are some better strategies that we can use, and instead of trying to follow more archaic, older strategies that have been proven to be not as effective as the ones we're currently using, we just put ourselves in position to kind of end up where we were just a few years ago. And as was already mentioned, I feel it's really important to recognize the amount of effort and work and progress that the state has made. And I think the reason why that is because we put so much emphasis on prevention, treatment, and recovery as a means to help people who are struggling with drug and fentanyl use. And I think that we need to continue focusing on that, even though we've still got a long ways to go compared to where we were and compared to other states, especially during COVID. We've done a really great job and continue to do a great job. And I think our efforts need to be continued in that level, and to steer away from trying to punish an illness that could essentially be better treated if given the proper treatment. Thank you.
Thank you, Mr. Chairman. Thank you for taking my question. I understand that you don't support the 5 grams provision that's on line 19, but the next sentence that's on line 22, line 21, mentions 28 grams. Do you have any opinion on the 28 grams having a mandatory sentence?
I do. I feel that at that level, there's a much more likely chance that it's somebody who is distributing and dealing it versus somebody who is just using or dealing in small amounts to support their own habit. I do think there's a clear distinction between the two.
I understand the distinction. I'm just saying you don't support you're against the 5 grams being a mandatory sentence for fentanyl class. I'm asking, would you oppose a mandatory sentence for 28 grams?
Is that bill on the table right now?
It's in the same bill. It's after the sentence that involves the 5 grams. It's a fentanyl class drug in a quantity of 28 grams or more, including any dilutants, shall carry minimum term of imprisonment, not less than 7 years incarceration.
I guess I haven't given enough thought into that to be able to give a direct answer at this point. But I apologize for missing that.
Thank you.
Thank you, Mr. Chairman. Good afternoon. Thank you for coming. You referenced a program you worked with at the Sullivan County Jail. Was it the SOAR program that is similar to the Merrimack County's SOAR program?
Actually, no, it was the Trails program. It actually was the first inpatient treatment program within a jail in the state. They've been around for I think it's been like 12 or 13 years at this point.
Okay. Follow up. Merrimack County has a program that's entitled SOAR that is specifically for this purpose. It includes incarceration for a minimum of 90 days and a year's worth of being followed after that. Do you put that in the crime and punishment bucket, or do you put that in the treatment bucket if somebody's sentenced to SOAR?
Personally, I put it in the treatment bucket. Even though they're being sentenced, they're still being sentenced to something, whether they accept it or not, that is treatment-based. The 3-month treatment program that I did at the Sullivan County Department of Corrections I feel, was and is very effective because people go in, they get sentenced to the treatment, they're required to do the treatment in-house, and then they work towards transitioning and reentering back out with work release, with an aftercare program. I see much better results for that. My biggest concern with this bill essentially is also to dead time, that people would have these minimum sentences, be in there for 3.5 years, and not getting minimal or not enough treatment that they need during that time. And then just being in those environments just reinforces negative habits. It can increase stigma. When people have an illness, now they're criminals. And it can force isolation on people, all of which are counterproductive towards a person's ability to enter into recovery.
One more, Mr. Chair. One more follow-up. I think the programs we're talking about are very, very similar. A consequence of not being successful in the SOAR program, and you can tell me if this is true there, is that you serve your sentence.
Yes.
There's a backup sentence. Is that true in that case too?
Yep. Yeah. Typically, the way the process works is you can either agree to the sentence and do the treatment and have a reduced sentence, or you can do your full time.
Thank you.
Thank you, Mr. Chair. Thank you very much for taking my question and sharing your experiences. There's a line within the bill that says a voluntarily induced intoxicated or drugged condition may not be considered impairment. When someone is experiencing substance use disorder, are they voluntarily involved in intoxicating themselves, or is there a medical condition, or is this a psychological choice?
Do you think you can reframe the question a little bit? I'm not fully
Sure.
understanding.
If someone's experiencing substance use disorder
Yep.
and they are using, and for the purposes of today's hearing, fentanyl, are they impaired voluntarily, or are they under their substance use disorder?
If I'm understanding the question correctly, I think that there is a point in time where it is impairment, and then it will turn into a substance use disorder. The choice in the matter becomes much less and much more limited the more a person continues to use, especially fentanyl. A person can be diagnosed with substance use disorder at a rapid rate and increase to like alcohol use disorder and other substances, because it quickly just holds on to people and puts them in the diagnosis.
Thank you very much.
Thank you very much.
Good afternoon, Ms. Lennon.
Is it on? My name is Michelle Lennon. I live up in Campton, New Hampshire, obviously, and I pastor the Northfield Tilton Congregational Church. And from my role in the church, ended up being one of the founders of what was the Greater Tilton Area Family Resource Center, which became Archways, which now has integrated recovery community centers and family resource centers in Concord, Tilton, Franklin, and Plymouth. My reason for opposing this is both personal and professional. In 2009, my husband fell off a roof 40 feet, and he lived through it. But at that time, in 2009, he was really overprescribed OxyContin by a surgeon at Dartmouth. And for a year was taking OxyContin 80s twice a day. When his workman's comp ran out, they just shut him off. And he had gone from being dependent on opiates for really living through chronic pain to a severe addiction to heroin. What I know is he was arrested numerous times, and at no time did that make a difference. It never initiated his recovery. What he needed was more support, and it was at a time where there were no recovery centers in New Hampshire, and there was a huge lack of support for individuals that have developed a disease of addiction. You know, I think about how there are many pathways to recovery, and there is no one pathway. And that is the thing that probably causes me the most concern about this bill. 5 grams was definitely personal use in his case. I mean, you can imagine the level of tolerance that he had that was, I don't want to say forced on him, because obviously when you live through a terrible accident and you trust your doctors, you do what they tell you. But there was a time when it wasn't a choice. I have often equated it, like even talking with our children about this, that it's like holding your head underwater. You can consciously know that you can hold your breath for 5 minutes, but you're going to take a breath long before that 5 minutes is up, even knowing the consequences of taking that breath is drowning. And we lived with it for a long time. At the worst of his behaviors associated with his addiction, he was homeless in Manchester for 3 years. When he chose to get into recovery for the first time, it was through a program called Teen Challenge in Manchester. And for 27 months, he did well. And similar to incarceration, you kind of live in a bubble. As soon as he was out of the bubble, he fell off like a rock. And one of the things that also concerned me professionally is we are working at doing these intercept programs to kind of intercept people before they end up incarcerated. What we know is forced sobriety is not the same as recovery. It's just not. And so when people are incarcerated, they are taking out of their communities, out of their home environments, and putting into an entirely different environment, and then expected to survive and thrive when they are returned to the same environment they left. And it's just not practical. One of the programs that we are working with DOC is called Peer Recovery Inside and Out. We have peer recovery coaches that are going now into DOC and the women's facility, into Shea Farm, transitional living, and into one of the men's programs to work with people on the inside so that when they go out, they know who to go to. Because one of the risks of forced incarceration, if people don't get the resources, if they don't get the right resources for them, because, the SWAT program is great. Like, there are so many programs that are great, but they're not customized to the individual, So what an individual may need may not be what the state can offer while incarcerated. For my husband's case, it was having a hip replacement. Once he had the hip replacement, he has been substance-free as far as any kind of opiates for a year. His last surgery was a year ago. He's solidly in recovery now. He was actually working today at the Homeless Resource Center. It's made the difference having the right resources. At no time did incarceration provide that for him. At no time. What it did is damage my family, because all of the burden of the legal financial obligations fell to me. Now, at the same time we were going through this as a family, I was putting my daughter through college. She graduated from SNHU. She has a degree in business administration. My son just passed his master's electrician license yesterday. He was going through school. And I think about, how different things could have been. Now, I stayed with my husband through all of his reoccurrences, but I had a lot of education. My background was in family support. I worked as a family support specialist, so I worked for somebody who gave me a lot of training as addiction was hitting all of the family support world's caseloads. I had the support of my friends from the recovery community centers, from the facilitating organization. I had this healthy social connection that I could rely on to support my family, but I also understood that this is a disease for people that struggle with this. We should not be criminalizing health conditions. Now, the behaviors that go along with that is something else. But when we're talking the amounts that you're talking about, this can be personal use because tolerance is a real thing. And so I am very opposed to this.
Any questions? Seeing none, thank you for your testimony.
Thank you.
Jake Berry. Good afternoon, Mr. Berry. How you doing?
All right, Mr. Chairman, how are you today?
Couldn't be better. Thank you.
Yeah. Mr. Chairman, honorable members of the committee, my name is Jake Berry. I'm the Vice President of Policy at New Futures. As many of you know, New Futures is a nonpartisan, nonprofit health policy and advocacy organization. We've been working for more than 25 years to help address substance misuse and addiction in our state. I don't want to repeat too much of what's been said here this afternoon, but I do want to stress our strong opposition both to this bill, SB 14, and to the following bill, SB 15. As you've heard, New Hampshire's come a long way over the last decade in recognizing substance use disorder for what it is, a chronic relapsing condition of the brain that requires treatment, not criminal punishment. We've worked tirelessly as a state to build our treatment and recovery systems around this concept, and thanks to the hard work of many, we're making real progress. You've heard about the declining numbers of fatal overdoses, of overdoses that we've seen throughout the state. Certainly over the last few years, certainly there's much work left to do, and every tragic overdose is one too many. But simply put, mandatory minimum sentences like these do little to address the problem. Data shows that mandatory minimums do not prevent overdoses, overdose deaths, or drug-related crime. Again, the data is clear that in states that do enact mandatory minimums do not see a noticeable reduction in any drug-related crime or overdose statistics. To the contrary, mandatory minimums capture more individuals deeper in our criminal justice system, making it more difficult to access the treatment they need where they need it and when they need it. And this increases the cost on taxpayers who foot the bill for their prison sentence. Certainly, I understand these bills are intended primarily to capture large-scale dealers, but the fact is it's impossible to draw a hard line. Many individuals caught up in dealing are users themselves in need of treatment for their underlying addiction. To deny them that treatment or confine it to behind the walls does little to address the underlying cause of their behavior, nor does it accomplish much to preventing overdoses or overdose death. Rather, it undermines the work we've done as a state to create a treatment system available to all who need it. For these reasons, we ask you to oppose both these bills and both MITL, and we look forward to working with you to find other ways to grow our treatment system and overcome this addiction crisis. And I'm happy to take questions.
Thank you, Mr. Berry. Yes, Senator Evans.
Thank you, Mr. Chairman, and thank you for taking my question. If I understood your testimony correctly, there's obviously someone who is an addict, substance abuse disorder, that's one person, but then there's the drug dealer. I understand they can be both, but for someone who's dealing fentanyl, do you believe there should be a mandatory sentence for someone who's selling fentanyl?
Again, I think in many cases it's impossible to it's really difficult to distinguish. I think the people who are often dealing are using themselves to address their criminal behavior, in this case dealing drugs, as opposed to the disease, the substance use disorder that they're dealing with. I think, again, I think it undermines the treatment system we've worked so hard to build. I think ultimately, putting people who are struggling with addiction in jail or a criminal setting does little to address that addiction. It does little to prevent the kind of activity that we're trying to prevent. It does not prepare them for life on the outside. So I think that, again, to focus on their behavior of selling as opposed to their experience as somebody battling addiction, I think does not help the system we're trying to build.
So for someone who does not have any tolerance, according to the DEA website, take that with what credibility you want, it would take 2 milligrams to kill the average adult. So 5 grams, if you could kill the average adult, over 2,000 average adults, okay? Now, if someone's then lacing that in other drugs, just because they're, addicted to drugs themselves, I guess my concern is that's what's killing people. If someone has a tolerance to 5 grams, I'm not sure I'm convinced of that.
Sure.
That someone is using just that for personal use. But if such a low amount of fentanyl could actually kill someone and they're distributing it, I understand the 5 grams, but the 28 grams provision, I think that's well beyond personal use. So why would there not be a mandatory sentence for that? Because that they're contributing to the substance abuse, at least in my opinion. They're selling it onto the streets, and people who are recovering are relapsing when people are selling it to them.
Sure, I appreciate the question, Senator. And again, I think you're trying to draw a line between dealers and users that I just don't know how you draw cleanly. I don't know how you institute a broad-based mandatory sentence like this in a way that does not capture individuals who are themselves battling substance use disorder and in need of treatment. I think that, again, the higher you push the number, perhaps there's a higher ceiling for this. But I don't know how you make the distinction that you're looking to make.
Thank you.
Thank you. No other questions. Thank you, Mr. Barrett.
Thank you, Senator.
Is it, I think it's Sean Carcass? I would have thought it was Caracas. Good afternoon, sir. How you doing today?
I'm doing well, thank you.
Great.
My name is Sean Carcos. I am a resident of Manchester, New Hampshire. Over the last 5 years, I've served as an assistant county attorney with the Hillsborough North County Attorney's Office. Over the last 3-4 years, I lose track of time, I have served as the lead for our drug prosecution unit there. I am here today not necessarily representing my office. I'm here representing the people of Manchester, my own personal views, but with the unique experience of quite literally living within 318B over the last 5 years of my life. I prosecute drug crimes more than anybody else in my office, and I believe more than anybody else in the state. So I'm incredibly familiar with 318B, and I think I'd just like to clarify something that I think a lot of people in this room might be missing. This proposed amendment is not going to say that anybody possessing over 5 grams would face these mandatory minimums. It would apply when they are shown to be possessing with the intent or selling that 5 grams, and they've had a prior conviction. I can tell you that if somebody was arrested with 5.01 grams, it's going to be a very difficult case to prove beyond a reasonable doubt that they were possessing that with the intent to sell, because as we've heard, that could be a potential personal use amount. Without any other indications that they were dealing, perhaps like a ledger, large amounts of cash, or prior statements from other witnesses saying that they were dealing, they're not going to be facing this consequence. I would not charge them with that if I just had 5 grams. Personally, I don't believe something under, let's say, 10, 15, or even 20 grams in and of itself is enough proof to prove beyond a reasonable doubt that somebody possessed more than 5 grams with the intent to sell. This statute, there are lots of lesser included charges within this. There's over 1 gram, no mention of quantities. So I'd just like to clarify that this is a very limited in scope amendment and a very limited in scope application. It would only apply to those who have prior offenses. Again, so this isn't somebody who's first time through the criminal justice system, even for dealing. They would not be facing these mandatory minimums. And to start with, for those reasons, I do believe that this is a beneficial amendment to the prosecution of drug crimes. I have heard it time and time again in court from judges, from defense counsel, and even in this room today, that addiction is a significant thing that's driving this behavior. But I really do believe that we've gone astray here to believe that dealing drugs, harming others is an acceptable action while somebody is struggling with addiction. Stealing a loaf of bread like an Aladdin to support someone's habit, to feed oneself, that's a criminal conduct that maybe we can understand when somebody's struggling with addiction. But to go out and intentionally harm others just to further your own addiction, there's so many other things people can do. And I do believe that there needs to be a message sent, not only to the community, but to the judges, that this kind of behavior, when you are selling drugs to support your habit or just selling drugs for sheer profit, and it's particularly if you are selling fentanyl, which we have seen killing people time and time again, the numbers may be going down, but I would contribute that largely to our the prevalence of Narcan, the distribution, and the awareness, more so than the actual amount of fentanyl going down. I've seen more of it than I ever have before. And I've seen the amounts that people are possessing go up and up and up. And so I do believe that the message needs to be sent that if you are selling fentanyl, that there are going to be significant consequences. And I think we need to take a little bit of the decision-making away from the judges because that they are correlating fentanyl with every other drug they've seen, and it's not. I've said it before in court, and I'll say it here, that if everyone stopped selling fentanyl and started selling crack cocaine again, that'd be an improvement. It's a terrible thing to say. Like it's not something I'm advocating for, but it's better than we are now. And if we can deter everyone from selling fentanyl because they're afraid of a mandatory minimum, and they go back to selling heroin, they go back to selling crack cocaine, we will have fewer people dying, fewer overdoses. And this statute, I do believe, as narrowly tailored as it is to address the fentanyl class of drugs for those who are only selling over 5 grams or over 28 grams, and for those who have had prior offenses, I do believe that this serves its purpose as a deterrent effect. It would not be overly abused and exploited, and it would be targeted towards those who have had those prior offenses, who have been through the criminal justice system and continue to engage in this criminal and lethal acts of distributing fentanyl. And it's, as I said, this is only applicable to fentanyl as I read it, and I would apply it. So this isn't somebody who is knowingly selling heroin and there happens to be a drop of fentanyl in it. It is somebody who is knowingly selling fentanyl, and it's that behavior. First and foremost, I think the state of New Hampshire, but in large part the city of Manchester, needs help curbing. Thank you.
Go ahead, Senator Ellis.
Thank you, Mr. Chairman, and thank you for taking my question. I'm not sure if I understood you correctly, but so are you saying that this would only apply to someone in a subsequent offense, not a first offense?
Yes, if you look under the line 2, section A there, it's describing that if any person commits a violation after one or more prior offenses defined by 318B27, such person shall be sentenced to, as we read. So it would only apply, it would not apply to everyone who possesses 5 grams. It would only apply if they have had a prior offense, is the way I would interpret it. And under 318B27, a prior offense is any conviction under 318B, misdemeanor or felony.
Thank you.
Go ahead, Senator.
Thank you, Mr. Chair. Thank you for taking my question. Just want to clarify something that you said in your testimony. Are you asserting that our current judicial system is not treating fentanyl cases with the gravity that you believe they should be? When you said that there's not a differentiation
I would
at
say
the sentencing level, is that what you're?
I would say that over the past 5 years, I've seen it sort of shift to a more of an acceptance of fentanyl as just another drug. I don't think there is much differentiation between crack cocaine, cocaine. I think there is. I would say crack cocaine and fentanyl are still treated as the same thing. I would say that there is sort of a differentiation from the justice system. Obviously, for things like marijuana, I think there's sort of an understanding for cocaine, but I don't see that fentanyl is really addressed or treated as dangerously as it is. I think we all acknowledge, the judges acknowledge, the court acknowledges that fentanyl is bad. I don't think they're treating it as it really is, that the lives are lost and that it is as dangerous as it is. I would also like to note that I did not prepare a speech for this, so I left out one of my qualifications. I also work with the Hillsborough County Drug Court Program, so I am very much invested in rehabilitation, in treatment for these individuals. And I do believe that, as we've heard, that people struggling with addiction need help, and incarceration may not be the best thing for them, but this is for those people who are selling these drugs. I've seen individuals go into drug court with addiction, with sales charges, and while sober, continue to sell. It's that criminal behavior that we need to target with this. It's not the addiction. The addiction may be a driver, but I've seen numerous people, countless people, who are struggling with addiction who will not sell drugs. They don't want to hurt others. It's the people who are using drugs, choosing to harm others for their own gain. That is, I think, what needs to be punished.
May I follow up? Thank you. One follow-up question. So in the context of this bill, though, fentanyl is not separated out. It's actually mentioned with heroin and crack cocaine in line 17 and 18. And actually, it sounds like if I'm understanding your testimony, that the legislature should be looking at pulling fentanyl out and addressing it as a substance all on its own, independent of other substances? Is that what you're kind of driving at here?
I think this statute does that. I mean, I would read it as, if you look at line 17, it's referencing, as you mentioned, heroin, crack cocaine, or a fentanyl class. And with
Yeah.
section A on line 19, it is mentioning a fentanyl class only. So, I mean, I think this statute does a good job at targeting just the fentanyl class. I think, thinking now that could be a problem with that is, I don't know if heroin falls into a fentanyl class. It's an opioid, but if the intent is fentanyl, then I believe that this is, as tailored, would be an effective sentence. I can tell you that we don't see heroin. I don't. I read every lab report that I get in all of my cases. I don't see heroin anymore. It's all fentanyl. So the question or the comment I heard earlier of how do you know that somebody's selling fentanyl? No one's selling heroin anymore. If you're selling an opioid, you know you're selling fentanyl because no one is asking for and no one is selling heroin. So it's just, I think it's naive to think that people are still selling drugs thinking they're selling or even buying heroin. I hear it from our drug court participants that they admit to using fentanyl. They admit to going buying fentanyl. They know what they're getting, and the dealers know what they're selling. So.
Senator Travis, go ahead.
Thank you, Mr. Chairman, and thank you for taking my question. Now, you mentioned that this would apply to possession with intent to distribute. In addition to just the quantity a person has, can you tell the committee any other factors or pieces of evidence you would look at that would be considered in a conviction on a case like that?
Yeah, it'd be a range of things. I would say the most common one we see is the way the drugs are baggied or are packaged, in baggies. If somebody has 5 grams and, it's in one bag, it's more likely than otherwise that it would be for personal use. If it's in 5 separate baggies, each for a gram, or if you've got 20 grams and you've got 10 baggies, then there's a clear intent there that, why would you have 20 separate baggies? That helps point towards that indication that somebody may be possessing that with the intent to give it to others. Again, this statute, this doesn't change the beyond a reasonable doubt standard that I would still need to face and still need to prove. So I would still need to present all those factors. And another one would be large amounts of money. I mean, you can find somebody with cash on their person. And as I think we know and we've heard, that people who are struggling with addiction, they're struggling with addiction and they're selling drugs to support their habit. If they've got $1,000 on their person alongside 28 grams, they don't need to sell that to support their habit. They've got the cash to support their habit. So that's an indication that they're possession with intent to sell. Ledgers, less common, but obviously a clear indicator if they have cash transactions and showing 5 grams for $100, $10 or $200, that's an easy indicator. And also we get, in confidential informant cases and sales, or even in cases where we just have confidential informants that are reporting, if we arrest somebody with a large quantity of drugs, but it may be borderline of whether or not they're possessing with intent, statements from outside witnesses who had purchased drugs in the past from them or have known them to sell can help to push it over the line for them.
Go ahead, Senator.
One follow-up. When this bill came up in the prior term, one of the objections to it was that if you had 2 people who were had substance abuse disorder and they would kind of share amongst themselves, so they're kind of passing back and forth. I understand, in its academic sense that may be distribution, but it's, I guess my point is, in your career as a prosecutor, have you ever prosecuted cases of possession with intent or distribution when it's really just 2, people at the street level really just interchanging the supply between the 2 of them?
I'm thinking they're rare because in that fact pattern, I don't know where the arrest happens. I mean, if you have 2 people sitting in a park, one of them's got, let's say 20 grams and the other one has none. Maybe we charge that. I would charge that one who has 20 grams of possession with intent, but maybe not. I mean, if they're sitting in the park, with needles in their hands or in their arms, again, there's the opposite side of, indicators of intent. There's the indicators of personal use. I mean, if people are actively using drugs together, the indicator is that the drugs they have on them is for personal use. It's going to be an uphill battle, if not an impossible battle. I mean, jurors aren't stupid people. They look at the facts and they look and see, you got a guy who's using drugs, 2 people using drugs together. Yeah, they might have had over a certain amount, but not dealing. I mean, like you said, I think you said it correctly, that if the allegation is that one of them gave to the other, that is dealing. But one of the things that if I have the privilege of applying to the law is prosecutorial discretion, and I think that this statute doesn't prohibit that. There's still a level of applying the law to the facts at hand, and there is a level of discretion here, where, as I mentioned, there's half a dozen lesser included offenses, and I could amend the charge here any number of ways to prevent a mandatory minimum sentence, such as removing reference to a prior offense, removing the amount in reference to over 5 grams, to allow for some flexibility and some discretion when there is that situation that arises. So this isn't necessarily a guarantee that if somebody has 5 grams on their person, or just over 5 grams, that they're going to be doing 3.5 to 7 years. So.
Thank you.
You guys all set? Okay, thank you very much for your testimony. Devin Chafee, come on down. I think you did. Okay. Yep.
Thank you so much, Chairman Gannon and other honorable members of the committee. For the record, my name is Devin Chafee. I'm the Executive Director of the American Civil Liberties Union of New Hampshire, and I am here today to testify in opposition to SB 14. And I just want to provide a little bit of recent historical context. And over the past 20 years in New Hampshire, both sides of the aisle have really worked to limit and remove mandatory minimums from New Hampshire law. And the reason why they have done that, why that has been the New Hampshire approach for over the past 20 years, is because mandatory minimums are expensive, they are ineffective, and they are a one-size-fits-all approach to justice that fails to take into account the particulars of a case. So first, I just want to highlight the tremendous cost burden that mandatory minimums puts on taxpayers. And here I'm going to quote Grover Norquist, which I don't often do. As many of you may know, he's a longtime tax reduction advocate, and he has stated that the biggest problem from the perspective of the taxpayer is that mandatory minimum sentencing policies have proven prohibitively expensive. According to Norquist, it appears that mandatory minimums have become a sort of poor man's prohibition, a grossly simplistic and ineffectual government response to a problem that has been around longer than our government itself. This is part of why New Hampshire started rejecting mandatory minimums and why we should be particularly concerned about going down this path at this moment. I know you all are very aware of the incredibly high cost of incarceration to this state. You just appropriated $60 million just to plan a replacement for the New Hampshire Men's Prison in Concord. That's not to mention the hundreds of millions of dollars that it's going to take to rebuild that prison. And I want to thank Senator Otschler for her thoughtful question about what does the Department of Corrections think about their ability to absorb the likely increased incarceration that would result from this bill. I believe that New Hampshire cannot afford to force more people into prison under laws that have no proven benefit. And that brings me to the second reasons why New Hampshire has historically rejected mandatory minimums. They simply do not work. We have been down this road. Across the country, these types of laws throughout the 80s and 90s were adopted. But there was no statistical evidence that those penalties did anything to reduce crime. And I want to give due respect to the inclinations of particular officers, particular individual officers and individual members of the community. But the bottom line here is the data is in. And these laws have not functioned to reduce drug use. They have not functioned to reduce crime. And they have not functioned to reduce overdose deaths. The bottom line is that we tried mandatory minimums and they did not work. As we've already heard today, here in New Hampshire, what has worked are the laws that you all have passed recently to make it easier for folks to access naloxone or Narcan. According to the New Hampshire Drug Monitoring Initiative, the availability of naloxone very likely contributed to a decline in overdose deaths through 2019. Moreover, just recent data we've seen, which Mayor Rouet quoted when he spoke, indicates an even greater decline in overdose deaths since Narcan became more readily available in New Hampshire pharmacies in 2024. It is these types of life-saving solutions that are proven to actually reduce drug overdose deaths, not imposing arbitrarily severe sentences that ignore the particulars of a given case. And that brings me to the third reason that New Hampshire has rejected mandatory minimums. Anyone who commits an offense subject to a mandatory minimum penalty is subject at least to that minimum, regardless of any circumstances that might mitigate their culpability or recommend a more lenient sentence. And I think the back and forth that we have seen here today, both with some of the experts in treatment, as well as folks from law enforcement, really indicate how important those details and facts of a particular case are. Is this person, in fact, suffering from drug use disorder and simply on a park bench, as the senator stated, sharing with the other person on the park bench who is also suffering from that same use disorder? Or is this person some kind of part of some drug ring who is greatly profiting from this transaction? These are important details to a case that a judge needs to take into account when they administer sentencing. What mandatory minimums do is they transfer that discretion away from judges and to the prosecutor, which from our perspective and from many's perspective is a real separation of powers problem. In fact, it offends our very notion of justice, where we are really requiring that the severity of punishment match the harm that is done by any given individual. So in sum, mandatory minimums are prohibitively expensive, provenly ineffective, and inherently unjust. And for all of these reasons, I respectfully request that the committee recommend SB 15 inexpedient to legislate. Thank you so much for your time.
Thank you, Ms. Chafee. Go ahead, Senator Ellis.
Thank you, Mr. Chairman, and thank you for taking my question. So, to my understanding, they don't manufacture fentanyl here in New Hampshire. Someone has to bring it into the state. And then from that point, when the person brings it into the state, if they're either going to distribute it or intend to distribute it, that could lead to someone's death, or they're otherwise exploiting someone's substance abuse disorder. To me, that they're contributing more actively to the problem than someone who just has substance abuse disorder. So I guess, how do we address the issue of people who are constantly selling this to other people, when it's resulting in death and otherwise exploiting their substance abuse disorder? If the mandatory sentence doesn't work, what kind of punishment would be appropriate?
So I would say, clearly what we have heard today from a number of the testimony, and thank you for your question, Senator, a number of the testimony that has been given here today is that this bill is not narrowly targeting the individuals that you target. It's much broader than that, as I think we've heard. So I want to be clear about that. I think if you look at statements that have been made by, you had mentioned, sort of the federal government earlier in their approach to some of these issues. If you look at the U.S. Bureau of International Narcotics and Law Enforcement Affairs, statements around how to limit supply, which is what I hear you talking about, people who are bringing it into the state, they number a number of different potential ways to reduce supply, much of which is about addressing demand and by supporting effective prevention, treatment, and recovery initiatives. And I'd be happy to provide you more from the U.S. Bureau of International Narcotics and Law Enforcement Affairs about how to address the supply issue. I will say that in what I have read, they are not suggesting that increase in mandatory minimums will do anything to address that problem. I just don't think that the evidence is there.
All set? All set. Okay, thank you, Ms. Chafee.
Thank you so much.
Does anyone wish to testify who came in late? I saw one person, but they left again. So we're out of that one. Anyone else who didn't sign in? Thank you very much. We will conclude SB 14 and move on to SB 15. You will. We have one sip of coffee.
We now open the public hearing on Senate Bill 15, an act relative to establishing a mandatory minimum sentence for the crime of distribution of a controlled drug with death resulting. Here to introduce the bill is Senator Bill Gannon.
Thank you, Senator Abbas. I'll just skip the parts that were covered in the last bill, but the big difference between this one is the death resulting. So now we know the person who sold the stuff and they intended to sell the stuff. So we're holding strict liability of not less than 10 years imprisonment. So again, I dealt with people from Seabrook, Kingston, Fremont, and this summer now Sandown, who came to me and said their young sons were buying pot or whatever they thought they were buying, and inside was fentanyl. So we had people who were knowingly selling drugs, and now they've resulted in death. So I bend over backwards that yes, rehabilitation is one of the corners necessary. The state has been working on that. But you come to a point when I face these mothers and they're saying that this person who took their son's life is still walking the streets of Fremont, at Fremont House of Pizza, they see them, and it just isn't just that they do no punishment. They knowingly sold a drug and took a life. They might as well pull the gun. So we want them off the street. The mother wants them punished. And if I take them off the street, I know for one thing I'm gonna do, they're not gonna be selling drugs out in the street during the time they're incarcerated. So I've at least protected everyone on the street. The mother's got her punishment, and while they're in there, we do want them to get rehabilitation. But again, I see a huge difference between this and the other bill. This one, you've taken a life, and so you've risen to a point where society really just has to address this. And that's the basics. Thank you, Senator Abbas.
See no questions? Thank you, Senator, for your testimony.
Thank you.
Now call Melissa Davis.
Good afternoon again. Thank you for the opportunity to speak on this matter. Again, my name is Melissa Davis. I am the director of the Criminal Practice Clinic at UNH Law. I'm also an associate professor who teaches there. I'm not here on behalf of UNH. I am here on behalf of the New Hampshire Association of Criminal Defense Lawyers, and I have been a criminal defense lawyer in New Hampshire for 20 years. I have handled death resulting cases. I have represented people in death resulting cases, and I'm familiar with many of the contexts in which these cases arise. And the concern is always that the way that this law is applied is that it is overbroad, and that it ultimately encompasses people who are not dealers. They are drug users. I understand the intent behind these laws. I understand the intent is to get at real distributors, people who are bringing drugs into New Hampshire and dealing in large quantities. However, I don't believe that that is who is going to be prosecuted under these laws. People who are going to be prosecuted under these laws are drug users, are people who are suffering from substance misuse disorder. And that's what we see time and time again, because most of the time, the cases where drugs are coming across the border or are in very large quantities are being picked up by the feds and handled by the U.S. Attorney's Office, even in these cases. And so we get to death resulting in this case. I would encourage all of you to take time to listen to the reporting that's been done by NHPR through the podcast on death resulting by Jason Moon. In this case, I think he's done an excellent job of covering it. But what I will say is what this ultimately does is take away the discretion from the judge. I've been in cases where they're, first of all, these cases are taken very seriously by the courts. The judges are taking very seriously the fact that people have lost their lives in these situations, and the circumstances under which the drugs that ultimately led to death were distributed are taken into account by the judges in these cases, and these mandatory minimums would not allow them to do so. So is there a difference between a person who has a history of perhaps dealing, who has is known to be someone who is dealing in the community, who is not a relation or a co-user with the person who died in this case. Will that person be treated differently than another person who I'll describe in just 1 minute? The answer is yes. That person will be treated and subject to very significant penalties, including up to and even greater than what this bill is seeking to get at. But the problem is those people who are simply engaging in use with others. I've had cases of clients who, are, one friend or one partner of two people who are currently using at the time is the one who goes and, gets drugs from someone else who is selling. They share together. The person who went and picked up the drugs, sort of hands the baggie over to their partner or their friend. And it's that person, and that person unfortunately passes away. And it's the other person, the partner in that situation, the co-user, the person with a significant substance misuse disorder as well, who is not selling, but simply procuring drugs for themselves, for the addiction and the illness that they are suffering from together, that is then charged. In that situation, the judge should have the discretion to understand the consequences, should have the discretion to know that, yes, we still criminalize that action here, and yes, there are consequences, and those people are still going to prison. But they are also, and they are being held accountable, but they should not be treated the same. And 10 years in that situation is really, I would say, draconian in terms of addressing the person who is the user or the co-user in that matter. Again, this goes back to cost, and I think in this particular case, obviously the cost is much greater. The cost of litigation is much greater. The cost of incarceration is much greater. But again, I would reflect on what I started with during my last testimony, is that what we are doing right now is what's best known to work. Over and over again, what decreases the number of overdoses is a commitment to prevention, treatment, and harm reduction. Those dollars can be used in those ways to support that. It is amazing what's happened in New Hampshire over the course of my practice. It is amazing what has happened in our communities in terms of having people enter recovery. It is amazing that when I can sit with a client now and they can tell me that they have a substance misuse disorder, that I can tell them that recovery is possible for them, and that it is not just a way of life, that they will be an addict forever, that it's who they are and that it is defining, but that recovery is available and there are resources in this state that can make that happen. And the money that we've spent and the resources that we've given have made this substantial difference here in this case, not laws like this one. I'm happy to take any questions.
Go ahead, Senator Evans.
Thank you, Mr. Chairman. Thank you for taking my question. So a person knows they have fentanyl. I assume at this point in time, I think it's common knowledge that fentanyl could be fatal. And regardless of that knowledge, they distribute anyway. If I handed out fentanyl to everyone in this room and 2 people died of an overdose, it wouldn't be outside the foreseeability of being shocked that happened. So although maybe in my heart I don't want someone to die, I'm engaging in behavior that I know could likely lead to someone's death. So I guess if it's not a mandatory sentence, I'm all about the harm reduction. I understand that would mitigate how often this happens. But when someone engages in behavior they know could kill someone, I think that Senator Gannon said when he testified, you shoot someone with a gun, you know what's going to happen. You see, maybe your intent is different, but nonetheless, the outcome is foreseeable. So I guess if it's 10 years is too harsh, what should it be?
I think it should be individually determined by the judges in this case with the maximum penalties that are already in place. You can face life. And so the judge, has the discretion to give a sentence that's appropriate in this case. I would say it's very different, a group of us sitting around with our mindset, with our knowledge, not affected by substance misuse disorder, making that decision, versus every one of us sitting around here in active use, thinking that if we don't get the drug, then immediately, the way we are going to feel is like we are dying. And that feeling is what we are focused on. That making sure that we don't feel like we are actually physically dying is our goal in this situation. And so as someone said, similarly earlier, you're going to take that breath underwater. You're going to take that breath because you don't want to feel this way anymore, even though there's possible risk in this situation. And I think that, you can't the mental state is actually really important here, but this law has, long, I think, been an issue because of that. And so who are we actually trying to wrap up in these situations? I don't think it's effective in doing what is intended.
Go ahead. I think if I understood you correctly, you're talking about the person who has substance abuse disorder that's trying to acquire fentanyl because they're suffering from withdrawal symptoms. I understand that person is in a situation where that's the only thing on their mind. But the person that is distributing that fentanyl to the person, and if they do that and the person dies, that's what I'm trying to get at. Is this is a person who's handing out something, they know it's within the realm of possibility, and then when it actually does happen, that known risk happens. When you say do it on a case-by-case basis, but vehicular homicide, right? I don't think people who are intoxicated, who kill someone while they're driving, set out that night because they wanted to harm someone or cause harm to someone. But it ultimately happened, and I think it's a known risk. Why is this any difference?
I don't think they're equatable in this situation, but I think what I was intentionally going for is if you have the person, let's just say with sort of the larger amount that's selling, right? Like, okay, maybe you think you're addressing that person. And if the facts show that, the judges will take that into account. And this sentence will be very significant in that situation based on what I've seen. But the problem is if that person sells to one other person who is maybe bringing back to a group of 5 who are all sick, and everyone in that situation, the person who brought the baggie back, the person who is in everyone around that circle, is all feeling the same withdrawal symptoms. The person who brought the baggie back is being charged as well with this law in that situation. And that person is, simply, it is a cause of the disease that they are suffering in that moment. So I understand the intent to get at the person who has the greater amount of drugs that's distributing to all of them. I get that. But when this law is applied, judges see that, judges know that, and judges can take that into account because the sentence availability to them is so great.
Thank you.
Go ahead, Senator.
Thank you, Mr. Chairman. Thank you for taking my question. I want to go back to the scenario that we talked about when Senator Gannon first introduced this bill and how painful it probably is for a mother in Fremont to not have her son and to have somebody else at Fremont House of Pizza who she knows or suspects is liable for that. There are statutes that exist right now that if a prosecutor has the facts and the evidence, he would be charging that
Correct.
person with or without a minimum. Having a minimum sentence doesn't change that scenario?
That's correct. I mean, the burden is still the same, the necessary proof is still the same, and the maximum sentence of life is still the same.
Thank you.
Thank you for your testimony.
Thank you.
Oh, you got the list. Mr. Karkas, do you wish to speak again? Thank you.
Thank you again. My name is Sean Karkos. I'm a resident of Manchester, New Hampshire, and over the last 5 years, I've been an assistant county attorney for the Hillsborough North Superior Court or County Attorney's Office. And over those past several years, I've been the lead for our drug prosecution unit, and I have handled a number of death resultings. However, I would note that it's not many. These cases are rare and difficult to prove. There are a number of hurdles in these kind of cases. One, drug dealing is very clandestine and difficult to prove, as it already is. Overdoses happen often. We don't see hundreds of death resulting cases a year. We see hundreds of overdoses and 100 overdose deaths, but not every one of those leads to a death resulting because they're very difficult to prove. And there's a number of complications. So these cases are rare. I'll start by saying that. I would also like to note that for every charge, every sentence, there are goals of sentencing, which are deterrence, punishment, rehabilitation, and deterrence breaks down to two forms: deterring the individual from acting again, and deterring the public generally from engaging in this conduct. And I think this statute, more than most, addresses that general deterrence and punishment better than most, or better than some, and it doesn't do enough, because I do think that a mandatory minimum is necessary here to ensure that general deterrence. Again, I mentioned it earlier, that if everybody stopped selling fentanyl or drugs that killed people and sold something safer, the state of New Hampshire, the country would be a better place. And if people can be told, and the general public knows, that if they sell a drug, or as Senator Abbas was indicating, gave a bunch of drugs to everybody at the party and people died, if they knew that they were going to be facing 10 years for that, they might think twice. They might pick a safer drug. They might not do that. And I think we're focusing here a lot on demand, reducing demand for drugs. And while I completely agree that that is half the battle, there is the supply side as well. And I think that there has become too much of a acceptance on fentanyl being, particularly fentanyl. I know this bill doesn't specify just fentanyl, but of the death resulting cases I've never had one that was a drug other than fentanyl. So it is the most common thing that is causing overdoses, and the most common drug that is resulting in these death resulting charges. But there's been too much of an understanding that fentanyl is okay to sell, and there are people in the street that don't mind selling it. And I've heard it from people who are convicted, and I've talked to them in drug court. I've heard it from officers, law enforcement officers, probation officers, that if somebody sells drugs, they typically sell all drugs. There's very few people that differentiate, that stop at, I'm not going to sell fentanyl because that one's dangerous. I think we need to put that in place. There needs to be a clear differentiation that you sell fentanyl, you're going to go to jail. And I think if you sell fentanyl and somebody dies, you're going to go to jail for 10 years. Well, I think the number could be debated of 10 years. There are a lot of sentences across the last decade, and there are not a lot of them that are over 10 years. Not saying that they shouldn't have been, but I'm saying that that number may be higher than it could be. But I do think that it needs to be clear that if you are convicted of, as I mentioned, something that is difficult to prove, if you were convicted of that, killing somebody by selling them a drug that you knew could have killed them, I think there needs to be a mandatory minimum sentence, and I think that will deter the public. Just to note, I've heard it from judges, I've heard it from defense attorneys, that you can't deter people struggling with addiction. They're going to do what they're going to do to get more drugs because they have an addiction. As I mentioned earlier, I think we need to stop saying that it's okay to sell more drugs, that is an accepted behavior. You need to deter it, and I disagree with that. If people are told, if I sell this particular drug, and knowing it's going to kill somebody, and it does, I'm going to prison for life or for 10 years, they're going to choose a different drug. Maybe they choose to sell something that we still don't want them to sell, but something safer. Then that's one step in the right direction. It's a slow and steady progress, but it's a step in the right direction. So for those reasons, I do believe that this statute is effective, would be helpful, and it would send a deterrent message to the public that selling these drugs, knowing that these drugs can kill people, hopefully that would send a deterrent message that we do need. Thank you.
Thank you. Go ahead.
Thank you, Mr. Chair, and thank you for taking my question. The seriousness of fentanyl is not unnoticed. It is not minimized here in this room. And the deaths resulting from the use of fentanyl are tragic and a horrifying situation that Senator Gannon's constituents are experiencing. This particular bill, though, does not pull fentanyl out of Schedule I and Schedule II drugs. And while a lot of the conversation here is about fentanyl, this particular bill, as written, includes Schedule I and Schedule II drugs. So if we were to stick with what's actually here on the page, what we're doing is possibly introducing a minimum mandatory sentence that would be, if I'm not incorrect, in your hands, because you're a prosecutor, right? So as a prosecutor, you would be the one that would be tripping this off, if you will? And if I read this correctly, would you not also have the authority as a prosecutor to use this for a 10-year minimum mandatory sentence for a death resulting from a heart attack from Adderall? An unknown side effect from someone using someone else's Adderall or OxyContin or Schedule 1 drugs, ecstasy. Marijuana is still a Schedule 1 drug. This bill would give you, as a prosecutor, a lot of latitude, would it not?
Yes, I mean, it would apply to more drugs beyond fentanyl. I would say that if it was a heart attack related to those uses, again, the burden is beyond a reasonable doubt, and I need to show that it was that drug caused that death. Typically, the case, as I mentioned, the cases that I have had with their death resulting, they're all fentanyl, but it's acute fentanyl toxicity. So it's not they had a heart attack or a seizure. It is that the fentanyl caused it. So it wouldn't just be somebody had Adderall, took Adderall, had a heart attack. It would need to be they had an Adderall toxicity. They had an overdose of that Adderall. And like I said, I've not seen any cases outside of fentanyl. But yes, this could apply to if somebody had methamphetamines or if somebody caused a death via marijuana. It would apply to those as well. And to an extent, I think that I don't know if that is problematic because, like I said, I've not seen it. I have not seen those drugs killing. And I don't really know that there should be much of a differentiation if you're selling a Schedule 1 or 2 controlled drug and it kills somebody. There's a reason it's a Schedule 1 or 2 controlled drug. And again, you need to prove that it is the cause of that drug is the cause of the death. So that burden still exists.
Well, thank you, almost.
Go ahead, Senator.
Thank you. I just want to follow up on something that Senator Altshuler just said. So it's actually not the judge who's going to make, he ultimately could make the decision about the minimum. It's whether you bring it under that charge that the judge gets the opportunity to do that.
Yes, if it's brought under that charge and convicted under that charge, then it would take away that discretion.
Thank you.
When you said earlier, there's very few death resulting cases.
Yes.
Would you have a ballpark?
I have
Statewide, you'd have your county, you probably have an idea.
over the last 5 years in my office, I've had 5.
Thank
And
you.
there are certain counties and certain law enforcement agencies that seem to be more effective, more productive at developing these. I have my own theories on that, but in Manchester, it's very difficult because you can walk down the street and get drugs at any time, and that creates a big barrier to proof beyond a reasonable doubt. You can have a text message conversation with your drug dealer at 5 a.m. If you're found dead at, midnight that same night, there's so many things that could have happened during that day. There's so many opportunities. So it's very difficult to prove, or it is difficult to prove beyond a reasonable doubt, that it was that particular sale and those particular drugs that led to it. So at least for those reasons in Manchester, they are very difficult, or in Hillsborough County, they're very difficult to fully bring.
Thank you. Thank you for your testimony. We appreciate it.
Can I add one note?
You can certainly add 2 notes if you'd like. Sure.
You had mentioned on SB 14 that the police chiefs had offered a proposed amendment to that regarding the cooperation. I think that would be applicable here as well.
Okay.
Because I think that one of the motivating factors to a mandatory minimum here, I think we discussed that if 2 people are on a park bench and they share drugs and one of them dies, in theory, they could be charged with the death resulting. But in my position, I'm more interested in where they got those drugs and who sold them those drugs. And if they want to cooperate, that's my goal. I have a death resulting case right now where that was the first call from the police department is they told me, hey, we've got a death resulting case. We want to know where she got it. And I think that there should be an exception for cooperation in here.
Okay.
While still recognizing that they've been convicted of death resulting. So.
We'll put it in both of them. Thank you. Go ahead, Senator Epps.
Just to follow up. In regards to that park bench example that kept coming up last year, and I'm just curious, in a case like that, we just have two people on a park bench, one of them overdoses, the other person's, not in the best condition, but they live, right? They come out of it. In a case like that, how exactly will you put a prosecution together that the person who survived was the person who introduced the drugs to that park bench scenario? I guess if one person's not there anymore, one lives, it's kind of hard I always thought it would be hard to put together, absent an ill-advised confession, of course.
That was gonna be my first suggestion. Get a confession, that would be the easiest way. And unfortunately, it's not uncommon, especially if you see somebody of your friends die, you might tell the police what happened. So that could be a reason for charging it. But aside from that, it would be very difficult unless we can show text messages, phone records, if they're available, are very valuable in these kind of cases. So if they were able to obtain the phone from the individual that survived and they see, okay, you were the one who coordinated a drug deal, you went and picked up the drugs. The other person's phone had no indication that they were doing that. That might be an indication that they were the ones that got the drugs, shared the drugs. So it would be difficult. And like I said, in the city of Manchester, where the drugs are unfortunately too easy to obtain, it adds another layer where we need to show that that drug deal that we might be able to prove or evidence was the one that killed it, and that killed the individual that passed away. And those are difficult situations. I've yet to come upon one of the death resultings that is that fact pattern. It's usually somebody, unfortunately, in their own home or discovered elsewhere. And unfortunately, it's very clear that they're buying drugs happen very close in proximity in time. So,
Thank you.
We're all set. Thank you very much. Devin, come on back down.
Thank you again, Honorable Chairman and other honorable members of this committee. Again, for the record, my name is Devin Chafee, and I am the Executive Director of the American Civil Liberties Union of New Hampshire, and I am here to testify in opposition to SB 15. Given my testimony on SB 14, I really just want to focus my testimony now on what I believe are the particularly egregious aspects of SB 15, which would create a mandatory minimum, as we've discussed, of 10 years for death resulting, which is a strict liability crime, of essentially passing drugs to someone else who then dies of an overdose. And I want to be clear that we all want to reduce overdose deaths in our state. And the many laws that this committee has supported are already having that impact, as we've discussed. But there is, again, no evidence to suggest that SB 15 will do anything to reduce drug overdoses. And I want to be clear that, and the citations to these studies are in the written testimony that we've submitted, that a majority of prosecutions in death resulting cases in this country are not against drug dealers. The bottom line, as was alluded to earlier, is that dealers do not often stick around long enough to be present when a person dies from an overdose. Instead, many death resulting prosecutions are against friends or family of the deceased, who are often themselves struggling with drug use disorder. And I really encourage you all to read the stories of some of the people charged under death resulting laws in our country. They include friends who were using together because they were too afraid to use alone, a husband whose wife bought heroin and then asked her husband to inject her, a wife whose husband had asked to use some of her prescribed liquid methadone to help him fall asleep, a woman who then, in addition to grieving her dead husband, found herself being prosecuted for his death. It is important to understand that in most criminal cases, you have to be aware that you are causing harm to be prosecuted. Even in vehicular homicide, you have to meet a mens rea of negligence, as was discussed earlier. There has to be some kind of intent. In death resulting cases, you can be prosecuted without having any intention of ill harm whatsoever towards the person who dies. That's what it means to be a strict liability crime. And that is why so many of these cases, as those I described, appear to be in tension with what our inherent sense of justice is. In short, these cases are the definition of why we need judicial discretion, why why it is so important to make sure that the punishment matches what we feel is fair. And SB 14 takes that discretion away. Moreover, there is no proof that high sentences for death-resulting prosecutions do anything to reduce opioid deaths, drug use, or crimes. And again, with all due respect to the particular opinions of individual officers and their experiences in individual jurisdictions, the data is in. If you look at analysis of death-resulting practices in New Jersey, Tennessee, North Carolina, Illinois, Louisiana, and New York, it shows that despite the dramatic growth in drug-induced homicide prosecutions in these states after adopting death-resulting laws, all of those jurisdictions experienced significant increases in overdose deaths. So according to the evidence, both mandatory minimums and the impact of death-resulting prosecutions on these policies, SB 15 is not going to save lives. And again, what has worked in New Hampshire, what has saved lives, are laws that you have all passed, making it easier for folks to access naloxone, which has contributed to a decline in overdose deaths since 2019, in addition to the decrease since early 2024, when all New Hampshire pharmacies were allowed to dispense Narcan. So, supporting funding and encouraging overdose prevention services, including increased use of Narcan, are ways to really prevent drug overdoses, not locking people away in prison for drug addiction without any consideration of the particulars of the case. In closing here, I want to know, and the committee has changed since last year, so there are new members of the committee. But last year when I was testifying against this same bill, I referred to my cousin who we tragically lost in 2020 to a drug overdose. And I know that so many of us probably in this room have experienced that type of loss personally in our family, within our friends. But today I want to end my remarks by reiterating what I said last year. Because when I think of my cousin, my handsome, funny, artistic cousin, and I think about what I would wish for him, what I wish for his friend or his girlfriend or his co-user to be jailed for 10 years as retribution for his death, or is what I really wish that he hadn't been using alone that night, and that someone with Narcan had been there with him and could have saved his life and given him another chance. And for me personally, the question is clear. For these reasons, I respectfully ask you to recommend that SB 15 is inexpedient to legislate. Thank you so much for your time.
Just two comments, just for me. So year after year, I talk to the police chiefs and I talk to the detectives who you've heard last year, I think it was Officer Murphy, and they tell us that it's going, if we do these mandatory minimums, the people that they arrest, we had Murphy, I think was 20 years undercover detective, and he says time after time, the only thing that's going to work is a mandatory sentence. And I understand you have your studies against it, but the thing that causes me to doubt your studies is a little, why would increase, you said a minute ago that increasing mandatory minimums actually caused increases in the behavior. Why would that cause an increase in the behavior?
Absolutely, Senator Gannon. I want to just say, like, we have gone down this path. It's not as if this is not a new proposal for a new policy, right? So we can see how these policies have actually impacted it. And that's what the studies are about, Senator. And that's why I believe those are important. I can answer directly your most recent question as well, which is what happens is, and what I think some of the experts from the recovery community that spoke earlier referenced, is that once people have a serious sentence, right? If they go to say to jail for 3 years, instead of entering a drug court treatment program or even a lighter sentence, the longer they spend in prison, the more likely they are to recidivate when they come out. They're more likely to go back because they are now so entrenched in the criminal justice system that it is that harder for them to reintegrate. And so what you can actually see from mandatory minimums is increases in crimes because of that, and increases potentially in the very behavior that you're looking to deter. And I have great respect for our folks that are doing this work the work of the police, out in the community. However, I think we owe it to the state, we owe it to the taxpayers to look at the data as to how these policies that failed for decades, what that impact actually has been and whether there has been any success linked to it. And I will tell you, Senator, I looked for that study that said that mandatory minimums had any decreased effect on crime or on drug use, and I could not find it. And so with that, that is respectfully why I am suggesting we not go back down this path. Thank you so much for that question.
Just one more thing. So do you see any role of punishment? I always, and again, I respect everything you're saying. Your side is, and I agree, you hear me every year saying, I have my stool and I want rehabilitation, I want to take them off the street. Now I also want to punish them. I never hear you say punishment. I never hear you talk about the deterrence of taking someone off the street. Do you think my stool with my 3 legs is inaccurate and you only need rehabilitation? Because that's all I ever hear, and I'd like to see more.
I am not suggesting that there be no punishment. I don't think with all due respect, I don't think that the ACLU of New Hampshire has ever taken that position. It's not the position of our organization. It hasn't been the position of this affiliate. But I don't believe that should be taken off the table. I do not believe that this bill is going to get us any further to solving the problems that we're seeking to solve.
Thank you.
Thank you so much.
We're all set.
Thank you very much.
I think that's it. Is anyone wish to testify in SB 15 who, come on up. I'm sorry, I might have missed you. Or I might not saw your check mark.
I just thought maybe you were scared of my name because it's hard to pronounce.
Hildreth?
No.
No, what's your last name?
No, my name is Anina. It's just unusual.
Oh, okay. I see you now.
I'm sure you're up to the challenge. Am I there?
Yep,
Yes, I
You're
did
there.
come. I knew I had a conflict, so Jake signed me in advance, but,
we're there.
okay.
Go ahead. Yes, ma'am. Thank you.
All right. Good afternoon, Chairman Gannon and members of the committee. Thank you so much. My name is Anina Hansen. I'm a resident of Peterborough. I'm a person in recovery from alcoholism, and I'm here to testify against SB 14 and 15. I just combining them into one.
That'll work.
A few years ago, I met the man I wanted to spend the rest of my life with. Phil Spagnuolo was a person in recovery from alcoholism and heroin addiction. He was also a successful small business owner and white-collar professional who served as a New Hampshire state rep and was running for state senate. But his plan to effect addiction treatment reform, as well as our plan to grow old together, was cut short in 2021 when he experienced a recurrence of his symptoms and died of a fentanyl overdose. Phil had prior convictions for both possession and dealing for many years before. During those final weeks of his life, when he was battling his opioid addiction again, had he been caught in possession of fentanyl and given a mandatory minimum prison sentence, it would have done nothing to help him recover or to make our state safe. Well-intentioned people, hardworking citizens, even public servants are struggling with substance use. When I was in active addiction, if I'd been caught in possession, neither I, my child, the community, or the taxpayers would have been better served by my going to prison than by my being supported to undertake this recovery journey that sees me today working full-time to help others avoid addiction. We all share the goal of mitigating the deadly impact of fentanyl and other substances that are wreaking havoc in our state. But the evidence shows that mandatory minimum sentencing is not an effective deterrent, and I believe that implementing it against people who are in pain is unethical. Locking them up is missing the point, as well as the opportunity to deliver interventions that really could help turn the tide. Even people selling fentanyl and knowingly harming others are often far past the point of choice and need to be treated, not simply punished. Legal consequences are appropriate, but they are ethical only when implemented alongside evidence-based practices that intervene at the level of the individual's pain. Somewhere out there is the person who sold my guy his final fatal hit. Somewhere are the people who manufactured that fentanyl, who ferried the supply. I don't wish any of them were cooling their heels in prison, draining our resources from behind bars. I do wish they were facing legal consequences that have been proven to decrease, not increase, their chances of reoffending. I wish they were being supported to contribute positively to our society and to be well. That's a beautiful dream, I know, but I want to be part of creating the world where it's a reality. We can approach this problem a different way. And that's why I'm asking you to vote against SB 14 and 15. Thank you.
Thanks for testifying today. We appreciate it. No questions? Thank you very much.
Thank you.
Does anyone else wish to speak on the bill? Seeing none, thank you. We are adjourned. Thank you very much.